All right, welcome to Truth Rising, and we are very happy today to have with us Loy Brunson, who is a brother of Raylan Brunson, who has a case before the Supreme Court. They have to decide whether the full Supreme Court will hear it, and he's here to tell us about it. And we also have on our call Jim Hogue. He and I regularly host Truth Rising, and a couple of other participants who are here to listen to you. We, as you know, attempted to sue the governor for the mandates and the constitutional abrogations, and we were kicked out for sovereign immunity. So we're very interested to hear what you're doing as far as bringing this case forward to challenge sovereign immunity. Would you like to describe sort of the broad base? Welcome, and thank you for joining us.
Thank you. It's great to be here. Thanks for inviting me. I'm using my handheld phone here, so it's going to be a little shaky. Maybe we can clear a few things up here so people can understand. I don't want to get into a lot of legal terms and stuff, but when you say kicked out, that's really so vague. It's like, you're not kicked out. What they do is they file a motion to dismiss, and then you file an opposition, they file a reply, and then the judge dismisses the case, but then you can appeal it to a higher court. And so we knew that we were going to be dismissed right at the get-go. We just wanted to get it dismissed quickly so we could go all the way to the Supreme Court. Now, there are many cases out of there that get what you say kicked out, which I would think means dismissed.
Correct.
But because of lack of resources, you can't go beyond that.
Correct.
And take it up the ladder. And then if you take it to the Supreme Court, there's so many cases that are eliminated even before they're docketed. They're eliminated. Many cases. So that's the first round. The second round is once you've been docketed, which we have, it goes to a hearing. It's actually called conference. So it's not the full-blown hearing, but it is where 9 justices get together in a room by themselves and vote whether to move it forward or not. So that, in a way, is a hearing. It's a conference, but it's not the final hearing. So you could say it's a preliminary hearing. In a way, you could say that. So right now, tomorrow, the 23rd of this month, the U.S. attorneys have a deadline of submitting an opposition to this petition. They have this opportunity to submit an opposition in behalf of their 388 defendants, which include Joe Biden, Kamala Harris, and 385 sitting members of the U.S. House and U.S. Senate. I call it U.S. Congress. The Constitution defines the House and Senate as the Congress. And we've mucked things up by calling the House the Congress and the U.S. Senate the Senate, and they're both the Congress according to the Constitution. And that's the tip of the iceberg of the confusion that's out there that turns people off from getting involved in politics. So I can tell you the whole story, just kind of, I'll try to, keep it as limited to points as possible, make it as interesting as possible. But it started with me and my brother. My brother has a lot of legal experience. He's not a lawyer, but he has represented himself in court on the state, federal, and Supreme Court level. He's actually had 2 petitions for writ of certiorari admitted in the docket and gone to conference with two petitions. So you could look up his name, supremecourt.gov, and you can see that. Now, if people want to go find a lot of details, we've just updated our 7discoveries.com website. They can go there and they can, if you scroll down and look at everything, you'll see a place where it says history and updates. And it will show the history of the 3 cases related to this one case. I was the first plaintiff. And then my brother decided to come along and do a second case, knowing that if we have 2 cases going towards the Supreme Court, one is going to make it before the other. So we had 2 shots at this. So mine was blocked in federal court. They wouldn't even let me file it. So we actually took them with a writ of mandamus to the 10th Circuit Court of Appeals, and they didn't agree that we were intentionally being blocked. So we took both courts to state court and litigated there. After that was over, while that was happening, my brother filed his case in state court against the 388 defendants, identical case to mine. The U.S. attorneys removed that to federal court, which we knew they would. And then they filed a motion to dismiss, and we lost that, which we knew we would. We just wanted to move it forward. We filed an opposition. They filed a reply. Then we went to the 10th Circuit Court of Appeals with an appeal. Once we're there, they sat on it for 3 or 4 months. So we got thinking they're going to sit on this forever and we won't make it to the Supreme Court. So we did some digging and we found that there's a special Supreme Court Rule 11 that if the court clerk accepts it as a national emergency, Rule 11, you can bypass the 10th Circuit Court. We did that hoping that they would accept it. They called us on the phone and said, we're accepting this. And we wanted, can you please add some more materials to your petition that we would want in it? We did that and we got it to them, and now it's docketed. We've overnighted it on a Thursday. They got it Friday. They docketed it Monday, and they showed that it was filed the day we mailed it express mail. So there it is. The U.S. attorneys have till the 23rd of November, 2022, which is tomorrow. And after that, they can schedule it for a conference, like I said, where the 9 justices get together by themselves, take a vote, and if we have 4 of the justices vote for it to move forward, it moves forward into a full-blown United Supreme Court case to be litigated. So that's kind of it in a big nutshell.
Well, I read the petition that you did, and I started out with this basic conflict between the objective principle of justice and the equitable maxim.
Yeah.
Which I think, could you describe what you mean by the objective principle of justice and
sure, that's a new term based on court documents. It's sort of a new term, so no one's going to be able to find that. But equitable maxim is just the opposite. My brother is the one that is the legal mind behind all this, but I'll give the best answer to that question I can. Equitable maxim, I believe, was something that the Supreme Court decided in the 40s. It gives all the judges in the country the power to toss out to dismiss a case based on their feelings that it's of unclean hands or that it's of a nature that shouldn't even be litigated. And so they don't have to give any reasons as to why they granted a motion to dismiss. So object principle of justice would be a new legal term that we're introducing into the court system that would go against that, where every judge is supposed to look at every single case and give reasons as to why he decided to toss the case. So the equitable maxim ruling has allowed judges and enabled judges to just willy-nilly toss anything they want for
right.
any reason they want, basically. So that's about the best explanation I can give.
Mm-hmm. Well, that's a very nice explanation. It's important because how can we have any faith in the justice system if they're just we don't know whether they're tossing it because of influence or
right.
And let's see, Morningstar.
So you can actually, and we refer to in our pleadings and our petition, we refer to his 2 petitions for writ of certiorari, that one of them is about that specifically, and you can reference that, and they can as well. So we referenced his other petitions at the Supreme Court so that they could look at that and see what we're talking about.
And I just wanted to make sure that I got the right website. When you say 7 discoveries, is it is that the SEVEN discoveries.com, or how do we write?
Either way, both work. 7, the number 7, then discoveries, or if you want to spell out 7, you can do that as well. They both work the same. .com, 7discoveries.com.
Okay.
And if people want to help financially with this case, if people could donate $1, that would be great. Mm-hmm. So if people feel like, oh, I don't have much money, but I could donate $1, that's wonderful. Be a part of history, make a $1 donation, join our cause, which is everyone's cause, really, to remove 385 corrupt members of Congress and 2 corrupt members of the executive branch.
And Morningstar has a question, but before that, in case people are watching who haven't gotten the the basics of the case, could you say what it is that you're claiming that why they are corrupt and what violation they made?
Oh, sure. Yeah, it's about the 2020 election, and it is not about who won. It has nothing to do with who won the election. It has everything to do with 100 plus credible witnesses, members of Congress, presented a mountain of evidence that we've included as affidavits as evidence in our complaint. Now, the petition is different than the complaint. The petition allows the justices to completely adjudicate the whole complaint, which you can download for $1 donation at 7discoveries.com. But so one of the causes of action is they deprived me and your right to participate in a sound, honest election by refusing a simple 10-day investigation prompted by a mountain of evidence that was presented by 100 credible witnesses, members of Congress, to the bodies of the Congress. And they refused a simple 10-day investigation. Mike Lee should have stood up and says, I have a constitutional obligation having to do with the electoral vote count, and I will do that as soon as we have this 10-day, simple 10-day investigation into it to make sure that we are allowing an honest electoral count. And he didn't do that, and a lot supported him and went with him in his direction. And those are the ones we are suing for depriving us the right that they are obligated to protect, to when evidence is produced proving that there should be an investigation, and they don't do it. That is serious, a serious cause of action. So we have 6 causes of action related to that. So it's about immunity. We're challenging their immunity. Article 6 of the Constitution of the United States requires that all officers, federal, state, local, be bound by oath to this Constitution. Well, since the Constitution was written, they've given themselves immunity through unconstitutional federal statutes.
Yeah.
And so that's another challenge. That's another point that we're challenging. We want that immunity stripped so that the Constitution can survive with the Article 6 that requires a binding oath. So more than just removing federal officers from office and barring them from holding public office the rest of their lives, we want to get rid of those unconstitutional immunity statutes that allow our representatives to get away with anything and everything. So once that happens, believe me, the people of this country can then freely hold their feet to the fire through the court systems.
Yeah, well, I mean, I thought that anybody here who hasn't read it, I thought that was so beautifully stated, because of course we feel like we can feel it in our gut how inappropriate it is that they're getting away and that they can't be sued, and it's this obvious. There's an obviousness to it, and the way you worded it was that the Constitution is not the thing that's conferring the rights. Rather, it's the instrument that measures the rights that were already there. And then you point to how it speaks of a higher God. You know, that's where they came from.
Exactly. It's there to protect the rights that we're endowed with at birth, our unalienable rights. It's there for that protection. And when the Constitution was signed with Article 6 demanding that they be bound by oath, that was serious business. And there have been some states that have actually changed their perjury laws to protect perjury claims against politicians having to do with perjury when it comes to the oath to the Constitution. California is one of them. Wow. So we need to expose that and get rid of it. And then I believe this is like the Achilles heel. Once we get rid of that, then people will feel like their time is useful in getting involved in holding their representatives' feet to the fire. But right now, most people feel like, what can I do to really make a difference? It seems like whoever we put in, they just do whatever the heck they want. We need to get back to a real representative government. And that's a very important part of this petition for writ of certiorari at the Supreme Court right now.
Let me see, I'm trying to decide whether to, Morningstar, you have a question that you want to ask. Do you want me to ask it? Shall I ask to unmute? But let me see. Morningstar is asking, did you file this as a tort or a claims? And did you use 18 USC 3231?
Okay, this is a civil lawsuit. Okay, my brother's the legal mind before us, so I can't get into the legal. If you want to see exactly what it is, go to sevendiscoveries.com. You can, for $1 donation, you can download the whole complaint with the full evidence, affidavits, congressional hearing documents that shows the evidence. You can do that. So, but it's a civil lawsuit. We did not go to the sergeant at arms to get permission. We did not seek a waiver. We did not go to the claims court, which is probably what a law firm would have had us do. We knew our rights were to take a case into any court were protected by the state and United States constitutions. We use those constitutions in our pleadings. And so my brother, for example, went to state court. The U.S. attorneys moved it to federal court, and we went right up, like I explained. Now, when I took mine to federal court, we learned a few things. We went there and we filed this lawsuit, and then we realized as soon as we filed it that we needed to we left a couple names off. And so we filed an amended complaint, and we thought that we needed to get permission from the court to do more than one amended complaint. Well, we discovered later that no, you can do as many amended complaints as you want if the defendants have not been served. Okay. So we thought we had to get permission from the leave of court file. We thought we had to file a leave of court document. So we did that, and they took the bait. Well, they actually acted like we couldn't file, and they did something good. They assigned a magistrate judge to help us, and she actually helped us. And she helped us follow Rule 8 more, which gives us more standing. It's about me. It's a lawsuit from me. I'm not representing the people or we the people.
Yes.
It's a member of we the people, me individually. How was I individually damaged? And so we took that approach, and then we realized, hey, we don't have to get your permission to file a case. You can't say that our case is deficient. And that's what they were saying. On March 31st, I believe, of 2021, the U.S. Marshal Service was ordered by the Federal Court of Utah to serve digitally, or to serve a summons and complaint to 388 defendants in Washington, D.C., at least 83, 87. I don't think Mike Pence was included in that. And so the U.S. Marshal Service, according to the docket, began serving the summons and complaint. The reason the U.S. Marshal Service was ordered by the federal court to do that is because of the lockdown. We could not hire process servers. We could not get a sheriff to do it. The only people that had access to serve summons and complaints with the U.S. Marshal Service. And because of that, the federal court ordered that to happen at no charge to us.
Oh,
and
wow.
so as they were doing that, they did it on March 31st. And so April 1st is when these people would start seeing that it was served. We're not even really sure they were served or not yet, because what happened is the federal court judge, an Obama-appointed Democrat, basically issued an apology and said, oh, this was a mistake. Brunson's complaint is deficient. It was a mistake. Ignore the summons and complaint. And so then we got into a battle about even filing the complaint. Well, we ended up with a fourth amended complaint. We did a third amended complaint, and they told us to do another third amended complaint. You can't do another third amended complaint. You do a fourth amended complaint.
Yeah.
So we kind of went through that a little bit with them. And finally, even after we had the third amended complaint, or the fourth amended complaint, all ready to go, the court wouldn't let us file it. They refused to let us file it. So we decided to take them with a writ of mandamus to the 10th Circuit Court of Appeals. That's like complaining to the higher court that the lower court's not doing the job. It's not an appeal because it's not a real case yet. So it's a writ of mandamus, petition for writ of mandamus, I believe. So the upper court upheld their stalling and said they're not stalling. And so we thought that was wrong. So we took both the 10th Circuit Court of Appeals and the federal court. It's the Utah District, U.S. District Court. That's the federal court of Utah. We took both those courts as defendants to the 4th District Court of the state of Utah. Wow. We filed that case there. So when we filed that case there, the U.S. attorneys filed a motion to dismiss. And because they were fighting my brother with his lawsuit, they admitted to things that we could use that to file a full summary judgment motion, so we would not have to go to trial with this. The judge could just see that they've admitted to things that we're claiming they did, they're admitting to, but they're claiming immunity, right?
Like what?
So
Like,
they're claiming sovereign immunity, you know, you
right,
can't sue members of Congress.
right.
So we file this motion for full summary judgment, and the judge sits on it. The state court judge sits on it, doesn't do anything.
And didn't you differentiate between that you were suing specific administrative acts, in this case, their failure to act to investigate credible claims of
No. This is a case against the two federal courts now for blocking my lawsuit.
Okay.
Okay, so this is a third lawsuit. This is not the defendants or the courts. The defendants are not the 388 defendants in the other two cases. This is a complete different case. We're suing the courts for blocking. So we're suing two federal courts and state court. We're suing courts. And so the U.S. attorneys actually filed some kind of document telling the judge to please make a decision because it's using he said that they were good this way. The U.S. attorney says our resources are being used up. We're waiting. This is stalling, and it's not helping Brunson, the plaintiff, either. Please make a decision. And if you make a decision to allow this case to go forward, we will then file a motion to dismiss. We will file an opposition to their full summary judgment motion. So look at this. Here's two federal courts represented by U.S. attorneys actually giving the power of adjudicating their fate in state court. This is a state court story, okay? If the state court judge had ruled in our favor, then the U.S. attorneys would have been obligated to appeal it in state court.
Oh, wow.
Okay, they could maybe try to move it to federal court, but if the state court doesn't allow it, they can't do that. So here's a real-time battle between state and federal that's never, I don't think it's ever happened. If it has, it's many years ago. This might be a first time in history that something like this has happened. And then they could have gone to the state Supreme Court and lost there, and then the Supreme Court could have upheld our win. Okay, and this is a $5.8 billion case, because when someone blocks a lawsuit, they become liable for the monetary damages you are asking in the lawsuit, regardless of the amount and regardless of the merits of the case. When they block your lawsuit, they're liable for your monetary damages. So we were going after them for $5.8 billion. And that's what the state court could have adjudicated. Okay. And so, but our state court judge didn't want to be a hero and go down on the right side of history. And so he allowed it to be dismissed. And then a few weeks later, I got a notice from the federal court that they had done what we were suing them to do, and that was unblock my case. Not only did the federal court unblock my case, but the federal court judge, the Obama appointed judge, Justice Shelby, the Chief Justice of the Federal Court of Utah, not only unblocked my case, but he ordered it to be filed, and he ordered the clerk of the court to issue the summons, the summonses. So within 2 days, we were over there with the printed out summonses, and the next day, every single one of the 388 summonses were signed and stamped by the chief clerk of the federal court. Okay, so now we're off and running. We get the defendant served, and that was very expensive because we couldn't do the marshal system now because of the COVID thing was not a problem. So we were doing it. It was very expensive. We were doing it through a special U.S. mail system that allows you file summons and complaints. It costs money, about $15 to $20 per
person. Yeah. So yeah, and watchers, people who are watching this in Vermont should know that every one of the Vermont representatives, Bernie, Leahy, and Welch, were served
every single Democrat was served, and many Republicans were served. It was not a partisan effort. It was a bipartisan effort, I guess you could say. So here we are serving them. And then Judge Shelby he's still sitting on it. They file a motion to dismiss. We file an opposition. They file a reply. We file a notice for decision, letting the court know we want a decision. It's probably been 6 months now. So while they're sitting on it, my brother's case, Rolland, his case is moving up and being adjudicated, but it gets stuck in the 10th Circuit Court of Appeals. They won't make a decision. And so, like I told you, we were able to bypass that with the Rule 11. The court calls us, said they will accept this as a national emergency, basically by allowing the Rule 11 petition to go forward. They ask us to include more documents that they see from the docket. They ask how soon can we get this, and they're encouraging, they're positive. We tell them 2 weeks, and we had it to them in a week. So we sent it on Thursday, the 20th of October of this year, 2022. They received it on the 24th. They docketed it on the 24th, but they show that it was filed on the 20th, which is what they're supposed to do because that's the day we mailed it. And they give the U.S. attorneys till the 23rd of November, which is tomorrow, to respond. And if they don't respond, they lose their right to file an opposition to it. And now the justices, after tomorrow, can go into conference, and they usually schedule the conference, and it's usually pretty quick, where they will have a date for conference where 9 justices get together in a room by themselves, and they will vote on this case. And if 4 of them out of the 9 votes, if we have 4 to move it forward, this moves forward to a full-blown hearing in front of the Supreme Court justices.
Well,
So
I think this is such an interesting time, and we spoke a little bit when I saw you in Salt Lake City,
Yeah.
and incidentally, I saw I think the courthouse that looks like a big cube, Obama's courthouse. I don't know if I can get a photo up for the show, but
Oh, he's talking about the federal court of Utah.
yes, it looks
Yeah.
like it's
Oh,
this.
it's a big, beautiful building. We were thinking, hey, if the court awards us this $5.8 billion, we'll go and take possession of that and lease it back to the federal government. Just a little humor to go along with it.
But you mentioned I had been successful in one case, and I think I had been successful in a state superior court, but I think I was successful specifically because the newspaper had basically dissed the judge and really gotten him
Oh, good.
angry.
There are
So
really good things that can come from a lawsuit besides a great award. Sure.
So here you have, we spoke about this, here you have the justices that have been attacked and maligned and threatened, and they haven't been protected by the Congress.
That's right. Now let's look at the justices. We have 3 justices that have actually ruled in favor of Trump-related electoral vote problems, okay? And who are those justices? Well, Alito, Thomas, and Roberts. Okay, so they have voted in favor of electoral vote related Supreme Court lawsuits. And so now we have Barrett, and we have Kavanaugh, and we have Gorsuch. Okay, and so here are 3 Trump appointed justices that are being threatened, like you just said. And they're not even staying in their homes, I was told, because of the threats, and it's not safe for them. Mm-hmm. And the Department of Justice and the executive branch and people like Chuck Schumer, they not only not protect these justices' rights to not have these people in front of their homes, but they encourage protests when they know it's a crime. You can't protest in front of a judge's house. You could maybe protest in the governor's house, maybe, but you can't protest in front of a judge's house. That's a crime. You're arrested for that. And were there any arrests made at all? So this implicates them even more. This implicates people like Schumer and the president and so on and so forth. So what I would like to see happen, I mean, we don't know what's going to happen, but I can envision the U.S. Marshal Service being given a court order to go to the Sergeant in Arms of Congress and handing over a list of names that have been ordered by the federal courts or ordered by the Supreme Court to have their credentials canceled. Mm-hmm. And so they would be notified, they should be notified, but if they're not, they would show up for their next session and their credentials wouldn't work. And I can just picture them playing with their cards, swiping them, or however they do it. And it's like coming up, canceled or not valid, not valid, not valid. And then I'm just wondering what the heck has happened. So,
well, what are the possibilities?
If this happened, they could become very upset at their legal representation. I don't think any of the defendants know that they're respondents in a Supreme Court case right now. I don't think they've been notified because the U.S. attorneys are so confident that they are immune. And why bother them? The U.S. attorneys were, and none of them have sought to release themselves from being represented by the U.S. attorneys in this group. Now, one of the causes of action is civil conspiracy.
Mhm.
And an attorney, a good attorney, knows that when you have a group of people coming to you to represent this group on when a cause of action is civil conspiracy, you don't represent everyone, because they can become hostile co-defendants, and then you can be charged with you can be liable for malpractice because you don't represent members of a conspiracy. They need to get their own lawyer, own attorneys. And when they do represent a defendant, they have to do a special background check. They have to find out if they've ever had any dealings at all with the 387 other defendants. And if they have, they need to withdraw and not represent one of them. And so I could see this turning into where there's 388 defendants looking for 388 different law firms that don't have any conflict of interest with any of the other law firms. And I mean, what a mess they have got themselves into because of their immunity claims and because the U.S. attorneys just felt like, yeah, we can just do this and get them free. And now here they are in front of the Supreme Court, and the Supreme Court has the final say. These 9 justices, these 6 justices that have been threatened and slandered, and the threats to stack the courts. And here they are with the ultimate power, more power than they've ever been given in the history of the United States Supreme Court. They now have the power to remove members of the federal government from federal office.
Are there any other outcomes other than removing them? Like, for example, ordering them to investigate, remanding them?
Sure. Yeah, there are reliefs. If you go to 7discoveries.com
Mhm.
and you go to, I think it's near the top, we put it near the top, but look for, I think it's court history and updates. I think it's something like that. And you can see all the causes of action. There's 6 claims, that treason is one of them, violating the oath of office is one of them. And you can see what the reliefs are. We're asking that they be removed from office. We're also asking that they be barred from holding office the rest of their lives. We're also asking that they're turned over to the Department of Justice for criminal investigation on grounds of treason. We're also asking for a monetary damage of $1 million per cause of action per defendant. That's for Congress, except I think Nancy Pelosi. So, and Mike Pence, Joe Biden, Kamala Harris, maybe Nancy Pelosi, I hope so. We're asking $25 million per cause of action. That's $150 million. We're asking for damages from the 3 defendants, and then $6 million per each defendant after that. That comes to $2.9 billion.
Mhm. Can I ask you, and this is, we're so thrilled. We're just I think everybody here is just like thrilled, and I want to give everybody a chance to ask you their questions.
Sure.
But I have one in particular. When I said our case got kicked out, what happened is the clerk just said that even though we had filed against the individual and the governor in his official capacity, they said he had sovereign immunity, and the judge did not write an order. The clerk said it's dismissed for that. And then we didn't.
Were you able to file it and serve the defendants?
Yeah, we served the defendants and all
You
that.
served the defendants,
We
okay,
had
then
it.
it was a lawsuit.
It was
Okay, so they
active for a
tossed,
year.
so did the attorney file a motion to dismiss, and that's where the judge tossed it, is because you filed a motion to dismiss? I think you were telling me about this. It's kind of weird what was going on.
Yeah, I
And
mean,
actually-
I had Tom Renz.
Now remember, I'm not an attorney. I can't
Yeah,
give
no, I'm
legal
not
advice.
either, but
I'm just giving you my opinion here. But go
yeah,
ahead.
no, but the thing is, Tom Renz brought a case about, not only cause of action was RICO, but also violations of the Constitution because of the mandates and the coercion of
Okay.
Nuremberg Act,
Okay,
all
well-
that stuff.
Well, that's what happened to us with my first case, is they wouldn't let us file it, and they were basically saying that I didn't have standing. And the way I understand that is we needed to follow Rule 8 more. And the magistrate judge that was assigned to us actually coached us and told us what we needed to do to make it about me, the individual, how I was personally damaged. And then I personally would have standing. And then there's a difference between filing in state court and federal court. Did you file in federal court or state
Federal
court?
court. So my question to you was,
Okay.
is that they said that I only had a month to appeal, and at the time we just didn't.
Yeah. Yeah, we missed our opportunity to appeal our case against the 2 federal courts because we were going back and forth. with litigation. And we thought that that would postpone the deadline. But then we realized, oh my gosh, while we're going back and forth litigation, the clock is ticking and we missed our deadline to appeal. I mean, we could probably have still done something, but we're thinking, hey, we're just going to focus on these two other cases here.
Okay, so the question now is whether it's dead in the water because.
No, it's dead. Yeah, you can't. You could file a, you could file another, there's the other time limits. And even if there are time limits, sometimes the judges will say, well, based on the circumstances, we'll allow it to move forward anyway. So even if there are time limits, so. But like I said, I'm not a lawyer at all.
Yeah.
So.
Well, let me open it up to everybody else to have access. Would anybody else like to say? Let me start with Jim. Is there anything that you'd like to ask or say?
Well, I just want to let Lou know that
It's
Loy, know that I've got a big smile. Loy, yes, I've got a big smile on my face the whole time at the nations that you had to go, that you had to conquer, and the your legal expertise in finding your way through the labyrinth, through the matrix. I love it because we, as you know, we went through it all and came out at the wrong end and followed exactly what the judge helped us too. He said, well, you have to do this, you have to do the other thing. Yeah. And then we did all that. And I thought I had done everything just right. And somehow, we didn't.
Well, you probably
so anyway, did. I congratulate.
Yeah, you probably did, but you missed your opportunity to appeal it. Go ahead.
Okay. Right. So anyway, I don't really have a question because I will be following the case and with great interest and letting everybody else know about it because I consider it to be a groundbreaking case that could turn out to be as important as any of the major legal decisions over the last couple of 100 years. So congratulations, and I look forward to watching it.
Thank you very much. We appreciate your support. Thank you.
Morningstar, do you want to unmute yourself? Oh, I don't know if
She said that Emily muted her. Or that Emily muted everyone.
Yeah, there were some sounds that I'm asking her to unmute. Or in the meantime, is there anybody else who would like to step forward? I don't.
You said something about it was in the state of Utah, and I recall that Dr. David Martin was, he experienced success in the state of Utah also. And was that a similar issue with you? Is that there's something?
I don't know anything about David Martin's cases. I had an opportunity to meet him, and I was curious to see if he'd had Supreme Court cases, and he indicated that he had been involved in a Supreme Court case, but I wasn't able to find it.
Oh, okay. That was last year, I believe.
Yeah. He said there was a Supreme Court case, but he didn't know what the docket number was and didn't know. He couldn't tell me anything to help me find it. If I knew who the plaintiff was or who the respondents were, that would. But it's a whole different thing. It's a completely different thing than what we're doing.
Okay.
Yep, I'm gonna mute Ariel, who just joined us, just because there's background sound.
There.
And Morningstar, are you on board now?
Hello, everyone. Sorry, Loy, thank you so much for being here. You are so encouraging and exactly what I think I needed, because I just started we started just talking about taking this to the Court of Appeals, loopholes, right? So I go at it, from like, and by the way, like Jim said, groundbreaking. This is the first of its kind, other than using the American with Disabilities Act or any like a crime proceeding for bias. Do you know what I mean? Where anybody has sued a court. And that is awesome. Like, this is heroic. So I was also plaintiff in the case. We kind of did it together. And what I was thinking, if we all filed separate, appeal for whatever reason, we could claim sovereign immunity, really. I mean, hey.
Well, what we found, this is important. What we did is we played by their rules better than they played them. Because what's happened is they don't totally follow their rules of civil procedure. They have their own little cultural kind of nuances. And so if you were to go to the federal docket and look at some of these things, you'll see strike lines where they've goofed up, where they've messed up, where they've made mistakes. And so you want to play their game their way with the rules that they believe they are supposed to follow. And then we knew we were going to lose at the beginning. We knew that these were going to be tossed at the lower levels. We wanted to go to the Supreme Court. That was our goal. And we got there with one of them. We'll take the other one there as well.
Yep. And the consent, from what I gathered, the sovereign immunity is why I was particularly interested in your cases, and I will be following as well. I'm definitely going to be going to buy just for all the citations and everything. But their consent to jurisdiction, their whole sovereign immunity thing, they have to like consent.
The dollar donation will get you the whole complaint. I think that it'll get you the complaint.
That'll be really helpful to get us started. Yeah, if anybody was interested in that. So I'm
not a lawyer. I can't give advice. So,
but that was going back to what you were saying, Loy, with the oath of office. I heard you mention that, you know what I mean? And that is basically under law, consent to jurisdiction, which is sovereign immunity then, if you really want to like dig it, everything in presentation with law. I do. I'm really excited about your case. Sorry, I'll shut up now. I could go on and on with the law stuff.
Morningstar, you mentioned it, an avenue for us to appeal would be that we would claim to be immune from the appeal length of time.
No, I wouldn't. I'm not going to give you advice, but you're not playing by their rules. Play by the rules they believe are real rules, and I wouldn't go common law on them or anything. But I can't give advice. Maybe it's a good thing to do. We've played completely by their rules. We even complied when they were violating our rights, and we were being nice and saying, okay, we want to file. What do we have to do? And we're at the Supreme Court right now. So I would just give them stuff that they can relate with and understand, and just lose in the lower courts. Get it to the Supreme Court. That's where you want it.
So there we go. We lost in the lower court, Supreme Court next. Thank you.
Right.
You bet.
But what I really liked about the way I imagine you and your brother were working pretty closely on the cases.
Two brothers. There's three of us.
Okay.
There's the legal genius with procedure, and then there's the other great part of this, that he's the plaintiff, Roland, and they've asked me to be the spokesman for both cases, since it was really my case to begin with that my brother was helping. Yeah.
But what I thought was so well done was pretty much how precise and efficient. Like one of the complaints about pro se people is, they'll go on and on and on and on, which I found myself doing anyway. But I really liked how you were able to be much more concise and say, no, we don't need a hearing. Yes, we can do. I mean, I thought that showed a great strength and confidence, and it probably helped your case a lot. But anyway, I admired that, by the way.
Thank you.
Yeah. So anybody else would like to ask any? So how long have you been involved in doing, well, you could be a lawyer. You don't have to be an attorney to be a lawyer. How long have you been really captivated by using the courts for our freedom rights?
Well, my brother's the one that's been captivated by the courts. I've been captivated by the Constitution. I started studying in around 2008 for the first time after hearing Obama say that the Constitution was fundamentally flawed. And I said, I got to read the document. I hadn't really read it all the way through. I don't think ever really in one sitting. And so I started discovering things that is like, wait a minute, I've never heard this before. So thus my 7 discoveries that have never been published for that I claim. And so as I began studying it, I was getting excited about different concepts, and I would talk to people about it and they'd never heard of it. And I thought, I was just rediscovering stuff that everyone else, knew, that were constitutional scholars or constitutional activists or studiers. And so I so I published this, you can see it behind my background. I published this pocket-sized book that highlights the power clauses that people need to be aware of. If you, for example, I tell people, if you were to ask a representative to show you a clause in the Constitution that prohibits socialism, they really wouldn't be able to show you a clear-cut clause unless they had my book and had gotten the idea from my book. And so, and then other discoveries, like I found that there was an interpretation clause. Have you ever heard that there's an interpretation clause in the Constitution that demands the Constitution only be interpreted in ways that protect your unalienable rights? That's in there. And I can explain those two concepts if you want, and others. There's Q&A in this book. It's yeah, the picture you can kind of see. Yeah, I'm out. I printed 10,000. I have two left. I'm printing another 10,000 2023 version that'll be available on the website.
Would you explain that point? You said you would and could about.
Well, one of the discoveries, yeah, that I was pretty excited about is this interpretation clause that I found. Congress defined the first 10 clauses of the Constitution as further declaratory and restrictive clauses. So I think it's a bit misleading for us, even though it's a bit misleading to identify those first 10 amendments as the Bill of Rights. It's like separate from the Constitution. Congress defined them as further declaratory and restrictive clauses to the 7 articles to the Constitution. So they are powerful. So the 9th Amendment, the interpretation clause, when I read it, I felt like it was the voice of God. It almost sounded like one of the commandments because it has shall not in it like a commandment does. And I'm sure you all know it. It goes like this. The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. No misconstruing parts of the Constitution or the Constitution in ways that disparage or deprive are the rights of we the people.
Okay, so let's come back to the 11th. Let's come back to the 11th, which is the one that, you know, they stand on. Isn't that the one they stand on to claim sovereignty?
What are you talking about? The 11th Amendment?
Mm-hmm.
What are you talking about? Well,
isn't that the one where they say that citizens of another state cannot sue the state
well,
government?
yeah, I don't even, you know, I'm not professing to know everything there is to know about the Constitution, but I don't have 11. That hasn't been my focus. My focus has been the Federal Reserve, money, and so you can come up with your own discoveries, concepts that people have overlooked. Yeah, probably more. So I found a few that I published in this book that I call 7 Discoveries. That, you know, and so
one thing that I found that I was really annoyed about was that I think it's the 11th. I don't have it right up in front of me to confirm that, and I don't want to misspeak and be recorded. But at any rate, it's the amendment that says that people cannot sue the states of another state.
Right. Well, the state can't sue another state.
Yeah,
right.
But it does not say that citizens cannot sue their own state. But yet they
actually
does.
Well, the Constitution protects our rights to sue anyone in any court, any entity in any court. And if you download the complaint, go to 7discoveries.com and download the complaint for $1, you'll see all the causes of action and all the legal and constitutional authority behind it. It's all there, just spelled out.
Mm-hmm. So what is you must have tons of interest. I've seen, you know, that people are picking it up in different
yeah, it's not, you mean the petition that is at the Supreme Court right now? Yeah, right. There are TikTok people that are exploding, and I see some of them are getting canceled. You know, they're no longer there. I saw one site where they were just reading the document and they had 28,000 views just reading the document. Yeah, it's kind of going viral. There's a phone number on the docket and people are calling that. We're trying the best we can keep up with that and to reply back with some information because people are a little confused out there. People think that there's a deadline of the 23rd where it's all going to be adjudicated and decided by the 23rd. That's not true. It's the U.S. Attorney's deadline to respond, and so there's a lot of excitement out there around it. And so this is about I've been interviewed quite a few times since I decided to go public with it. You know, about a couple of weeks ago. So it's starting to pick up.
Can I ask a question?
Go ahead.
So, well, it's yeah. there's this TikTok that I saw the other day, and it was this lady saying something exactly about what Loy
Yes.
Was saying. And it's the 23rd that the Supreme Court has to do whatever with, and then
Yeah.
they can't file whatever, and they have to continue, and 9 justices have to meet.
Well,
But there
what
was
happens?
something
Yeah, I can
there was
explain that.
something
If you look at the
there was-
docket, the docket says respondents have till the 23rd to respond. That's all it says. What that means is the U.S. attorneys can respond with an opposition if they want. They don't have to. They're not required to. It's not going to, that doesn't mean they lose the case. They don't have to. They can if they want. But the Supreme Court clerk has asked us to include stuff in there that would be just like their opposition. So they wouldn't have to. We told the U.S. attorneys that we've already included their motion to dismiss, so filing an opposition wouldn't really be necessary in our minds. And they haven't filed one yet. So if they don't do it tomorrow, then that right is waived. And then the court can freely move forward. They can give them an extension if they want. But then the court, as soon as that deadline happens tomorrow, Friday, we could look at the docket, and there would be a calendar date for a conference, which is a hearing in a way. But a hearing usually has the plaintiff, defendant, and they argue it, like a court hearing. This is a conference where the 9 justices, only them, no attorneys, no one else they're in this room, they're there by themselves, and they take a vote. And out of 9 votes, whether to move this forward or not determines whether it goes to the main full-blown hearing. Now, a lot of cases don't make it through the hearing. We may not make it through the hearing, but at least we've made it to the hearing, and we believe that we're going to make it through the hearing. And once we make it through the hearing, that's 1 in 100 cases that are at the conference over, that's the averages. Only 1 in 100 that go to conference make it past conference into a hearing. And so if we make it out of hearing, then full steam ahead.
And that's huge.
Yeah, the lady was saying that after the deadline, the 9 justices meet in the conference. But there was something in there about the First Amendment, and I couldn't help but ask, couldn't you use the First Amendment, and couldn't we just, I'm personally not part of this, I'm using this for school, but couldn't we personally just use our First Amendment and claim sovereign immunity? Because I know that the First Amendment says that we have
well, that's you're gonna have to go that's a whole different world than what I'm in right now. That is completely, it's like I'm talking about tennis, you're talking about football. Okay. So we're on the tennis court, and we can't apply football rules to the tennis court. All of our work is done. We're done until it moves out of conference. Once it moves out of conference, we litigate. There's some documents we need to provide, and we need to prepare for a hearing and testimony to encourage the justices to do what we want them to do. But the justices can this is a national emergency. They approve this under Rule 11, which means national emergency. So they can adjudicate the whole case, not just, usually Supreme Court will uphold a lower court's decision or reverse a lower court's decision. This type of case, they can completely adjudicate the whole complaint with its 6 causes of action and they have all the evidence there in the complaint that they have access through the court docket system. But right now, just the petition is very condensed, and it allows them to go and look at all the other information and make a determination whether this should move forward or not. This is the Supreme Court. They can do anything they want. They can throw out any case they want. The clerks they have the job of throwing out cases before even justices see it. But when they throw out a case, they usually will send the petitions back with an explanation of why it wasn't accepted and give them an opportunity to make the corrections. If they're there too soon and they haven't got the final say from the lower court, the court clerk will let them know, you've got to get a decision. You didn't get a decision. You have to do this. So a lot of cases are thrown out permanently at the get-go. Some come back after they make the corrections requested by the court clerk, and then conference is the big event prior to the biggest event. And that is the 9 justices voting with if we get 4 to 5 in favor, all we need are 4 to move this forward, and it moves forward. So that's what we're hoping and praying for, is that 4 justices are in favor of this moving forward.
Loy, we're at the top of the hour, and we will all be praying and rooting for you and
Okay,
standing.
Emily, you asked us for questions, and I've got one.
Well, we're at the top of the hour, Jim. Is it quick?
Yeah, there seems to be a criminal aspect to what you're talking about, as well as other aspects. Is there any opportunity that the law that will step
that's
in?
one of our reliefs.
Because
That's
in
one of
Vermont,
yes, we're requesting with one of our reliefs that they be referred over to the Department of Justice for criminal investigation of treason and violating their oath of office.
okay,
Yes. So
thank you.
we need a new Department of Justice. We need a new
Yes, we do.
DOJ. We need a
Yes.
new,
Well,
and that would happen within the president. So yeah, so there, it's all there.
You know, I think people have just been so, sheepish about approaching it in that manner.
Well,
And
they
it's
haven't
about
known what to
time,
do.
it's about time that people do,
They haven't known what to do. It's like your cases. You know, my brother would tell you, it's like you expect to get thrown out in the lower courts. You've got to be ready to go all the way with this. Otherwise, you may be wasting your resources, you know?
Yeah.
So we had a plan, and it's working. He had done it before to the Supreme Court. Now the Supreme Court has the final say. We got it to them. We took them on a silver platter, the most important, the most powerful case the U.S. Supreme Court has ever received. They now have the power to push back. They now have power to drain the swamp that started to drain. They can pull the plug. So we're
Very
hoping they do.
good.
Well put, well put. Oh, thank you, Loy. I'm gonna call it an evening, and
Yeah.
I'm gonna stop the recording. This is Truth Rising. We've been really, really blessed to have Loy Brunson today.
Yeah,